Please be seated. The sitting is resumed. I now call Mr. Paul Reichler to the podium. You have the floor.
Thank you. Mr. President, members of the court, it is, as always, an honor for me to appear before you. And it is a privilege, as well as a great responsibility, for me to represent the Cooperative Republic of Guyana
in a case that the Honorable Foreign Minister has described as existential for his state.
I will address you on the 1897 Treaty of Washington, the treaty between Venezuela and Great Britain by which they agreed to arbitrate their territorial dispute, and pursuant to which the dispute was arbitrated 2 years later, resulting in the award of 3 October 1899. In these proceedings, of course, Venezuela challenges the validity of that award. The first reason it gives for the alleged invalidity of the award is the purported invalidity of the 1897 treaty. Venezuela contends that the treaty was invalid, and therefore that the arbitration that was conducted pursuant to it was also invalid. And for this reason, the legality of the 1897 treaty has been put into issue in this case. As the court is well aware, Venezuela accepted, respected, and complied with the 1899 arbitral award for more than 60 years. The very first time it formally challenged the validity of the award was in a letter from its permanent
Representative to the UN to the Secretary General in February 1962. At that time, and in subsequent presentations to the United Nations, Venezuela made clear that although it had changed its position on the award of 1899, it continued to regard the 1897 treaty as a valid treaty. It was not until 1963, 66 years after it ratified the treaty, that Venezuela first began to find fault with it. My presentation on the treaty will be in 4 parts. In the first part, I will set out the issues in this case on which both Venezuela and Guyana agree, or at least which they do not dispute. In parts 2 to 4, I will address the 3 specific challenges Venezuela has made to the treaty's validity, all of which Guyana considers groundless. I turn to part 1. As a general matter, the parties do not dispute the circumstances that led up to the 1897 treaty. In particular, they agree that the dispute over the boundary between Venezuela and British Guyana began to heat up in the 1840s, and that between then and the early 1980s, Venezuela and Great Britain exchanged various proposals for delimitation of the boundary, all without success. Both states claimed the entire territory between the Essequibo River in the east and the Orinoco River in the west. Their respective proposals and counterproposals failed to resolve or even substantially narrow this dispute. Throughout this 40-year period, Venezuela complained about what it considered the westward expansion of British settlement in the territory between the 2 rivers. Although, as you have heard, an agreement was reached in 1850 not to expand further into what they both referred to as disputed territory, Venezuela complained that British expansion continued. Recognizing that it was unable to stop the British diplomatically or militarily, Venezuela implored them to settle the dispute by arbitration. But the British refused. As Venezuela acknowledged in its counter-memorial, quote, it had repeatedly proposed to Great Britain to settle the territorial dispute by arbitration, but Great Britain had systematically refused such solution, end of quote. It is also undisputed that between 1883 and 1895, in the face of what it claimed to be ongoing British settlement in the disputed territory, Venezuela turned to the United States for support, specifically requesting U.S. intervention with the British to obtain their agreement to settle the dispute by arbitration. To this end, this is what Venezuela's foreign minister wrote to the U.S. Secretary of State in 1883. To carry this controversy to a practical ground and possible termination, there is, in the opinion of the President of Venezuela, only one, and at the same time very simple way, arbitration. And for arbitration, there is only one government who could propose it with real effect and decide the question of boundaries to the satisfaction of Venezuela, the United States of America. It is also agreed that the United States responded sympathetically to Venezuela's entreaties, that it remonstrated with the British over the alleged westward expansion of British Guyana, and that it insisted on arbitration of the territorial dispute. No less a figure than the President of the United States, Grover Cleveland, championed Venezuela's cause. In September 1988, Venezuela's mission in Washington wrote this: to the President of the United States, Grover Cleveland, my country is largely indebted for his sympathy and the notion taken by him toward the government of Great Britain in showing that government that the United States was not indifferent to the unwarranted acts of encroachment by Great Britain on the territory of the Republic of Venezuela. The timely interference on the part of President Cleveland has, for the present, stopped the English government in her attempted acts of spoliation, encroachment, and appropriation to herself of very nearly one-third of our whole republic. My government and people feel that in President Cleveland they have a friend and protector. Despite the efforts of President Cleveland and his administration, the British remained opposed to arbitration with Venezuela, leading Venezuela to break diplomatic relations. In December 1894, with the territorial dispute continuing to fester, Venezuela's minister in Washington, José Andrade, a name you will hear frequently in this presentation, wrote to the U.S. Secretary of State, citing the threat of further British expansion and urging the United States once again to intervene on Venezuela's behalf. As Your Excellency will understand, the dispute already has a phase that we would call threatening, given that the colonial authorities are preparing to expand their jurisdiction even further, and to thus enter into regions where the Republic has established regular centers. In view of this, my government reiterates to the United States government its request for effective and direct intervention, which our Minister Plenipotentiary presented to the Department of State in Washington some time ago and has continually ratified. Within days, President Cleveland responded in an address to the U.S. Congress. I shall renew the efforts heretofore made to bring about a restoration of diplomatic relations between the disputants and to induce a reference to arbitration, a resort to which Great Britain so conspicuously favors in principle and respects in practice, and which is earnestly sought by her weaker adversary. When the British continued to resist President Cleveland's demand for arbitration, the U.S. applied greater pressure. In July 1895, the new U.S. Secretary of State, Richard Olney, another name that features prominently in the narrative, instructed the U.S. mission in London to convey the following admonition to the British authorities. The duty of the President appears to him unmistakable and imperative. Great Britain's assertion of title to the disputed territory, combined with her refusal to have that title investigated, being a substantial appropriation of the territory to her own use, not to protest and give warning that the transaction will be regarded as injurious to the people of the United States, as well as oppressive in itself, would be to ignore an established policy with which the honor and welfare of this country are closely identified. When the British ignored this warning, President Cleveland took matters into his own hands. In his December 1895 address to the U.S. Congress, he expressly invoked the Monroe Doctrine against the expansion of British Guyana, warning the British that, quote, its enforcement is important to our peace and safety as a nation and is essential to the integrity of our free institutions and the tranquil maintenance of our distinctive form of government. Sentiments in the United States, including at its highest levels of government, ran so strongly in favor of Venezuela and against Great Britain that, as Venezuela's foreign minister told the UN General Assembly in 1962, quote, the United States was on the verge of going to war with Great Britain. In this extremely grave situation, that's how Venezuela described it, President Cleveland, with the full support of the U.S. Congress, went beyond words to concrete action. He announced the creation of a new presidential commission of experts, headed by a U.S. Supreme Court Justice, David Brewer, to investigate and report on the true boundary between Venezuela and British Guyana, which the U.S. would then seek to enforce. As President Cleveland explained, when such report is made and accepted, it will, in my opinion, be the duty of the United States to resist by every means in its power, as willful aggression upon its rights and interests, the appropriation by Great Britain of any lands or the exercise of governmental jurisdiction over any territory, after which investigation we have determined of right belongs to Venezuela. This measure, with its implicit suggestion of military intervention by the U.S., finally broke Britain's resistance to arbitration of the dispute. In its written pleadings, Venezuela acknowledges this. If the British finally accepted to enter into an arbitration process, it was under U.S. pressure, and to ward off the risk of seeing the work of the Venezuela Boundary Commission concluding, as it had to, that the true boundary had always been the one claimed by Venezuela. As Venezuela further acknowledged in its counter-memorial, it is a fact that Venezuela requested the protection of the United States in order to resist Great Britain's conduct and reach a peaceful solution to the territorial dispute. It was clear that the possibility of submitting the dispute to arbitration could have materialized only with the support of the United States. And Venezuela continued. Great Britain accepted arbitration only because of the pressure put on it by the United States. Neither this conclusion nor the antecedent events that led up to it can legitimately be disputed by Venezuela at this stage of the proceedings. Nor can the fundamental features of the ensuing negotiations that led to the 1897 treaty. In particular, it is beyond dispute that the negotiations were conducted until the final stage directly between U.S. Secretary of State Richard Olney and the British ambassador in Washington, Lord Julian Pauncefote. It is uncontested that Venezuela appointed a team of 2 representatives, Jose Andrade, its minister in Washington, and James Storrow, an American attorney who had represented Venezuela before President Cleveland's Boundary Commission, to liaise and engage directly with Secretary Olney and assure that Venezuela's interests were reflected in the treaty negotiations. It is also undisputed that the negotiation of the treaty took place between January and November 1896, that a draft agreement was presented to the Venezuelan government in November 1896, that further negotiations took place directly between Venezuela and Great Britain thereafter, and that Venezuela then authorized Mr. Andrade as minister plenipotentiary to sign it, which he did in Washington on 2 February 1897. Later that month, on 20 February, the president of Venezuela, General Joaquin Crespo, submitted the treaty to the Venezuelan Congress with a message calling for its ratification. In so doing, the Venezuelan president expressed gratitude to the United States for the part it played in negotiating the treaty. It is eminently just to acknowledge that the great republic endeavored persistently to direct the matter by the most favorable route, and that the outcome achieved represents an effort of intelligence and will worthy of praise and gratitude from those of us who are familiar with the intricate details of this very complicated matter. The treaty was then ratified by the Venezuelan Congress by legislative decree on 17 April 1897. The final page of this decree is at tab 5.1 of your folders. None of these facts, none of them, are or can legitimately be disputed. I turn to part 2 and Venezuela's main challenge to the validity of the 1897 treaty. This is its contention that it was excluded from the treaty negotiations and that the treaty was, in its words, negotiated by the U.S. and Great Britain, quote, behind Venezuela's back, in collusion with one another to further Britain's interests at Venezuela's expense, with the result that, to cite Venezuela's written pleadings, the treaty was, quote, prejudicial to the interests and dignity of Venezuela in respect of crucial issues. Venezuela argues in particular that as a result of this purported British and American conspiracy, its views on 2 issues that it considered most critical, concerning the acquisition of title by prescription and respect for the 1850 agreement between Venezuela and Great Britain, were not taken into account or reflected in the treaty. The argument is that this purported Anglo-American cabal not only prejudiced its interests, but constituted a fraud on Venezuela within the meaning of Article 49 of the Vienna Convention on the Law of Treaties, sufficient to invalidate the treaty. On the same allegations, Venezuela argues that it ratified the 1897 treaty in error, as defined by Article 48 of the Vienna Convention, on the mistaken understanding that the treaty text negotiated on its behalf by the United States had protected its vital interests, only to find out during the arbitration 2 years later that it did not. Mr. President, neither Venezuela's contention of fraud nor its contention of error withstands scrutiny or is even plausible. In the first place, its contentions are counterintuitive. They strain credulity, requiring you to conclude that the United States, which between 1883 and 1896 had consistently supported Venezuela in opposing British colonial expansion and demanding that Britain accede to arbitration of the territorial dispute, made a complete volte-face when negotiation of the arbitration agreement began by switching sides and supporting Britain's interests in the disputed territory to the prejudice of Venezuela's. For Venezuela, this would be a hard sell in any case, let alone a case in which it expressly agrees, as you have seen, that but for the full support of the United States and the pressure it applied to Great Britain, including the threat of U.S. military intervention, the British would never have agreed to arbitration and would have continued to strengthen their hold on the disputed territory in the face of Venezuela's incapacity to stop them. But beyond its illogic, Venezuela's argument is also counterfactual, completely so. It is thoroughly contradicted by the contemporaneous documentary evidence of the treaty negotiation process that is part of the record in this case. I will take you to the key documents presently. The arbitration agreement was largely negotiated directly by the British ambassador to the United States, Lord Pauncefort, and the U.S. Secretary of State, Richard Olney, on behalf of Venezuela. At the time, there was no objection by Venezuela. There is no evidence of any kind of such an objection. To the contrary, the evidence shows that Venezuela trusted Mr. Olney, as well as his boss, President Cleveland, to protect its interests. And it believed Secretary Olney would have more influence with the British than its own representatives. This is confirmed by what Venezuela's Ministry of Foreign Affairs reported contemporaneously in August 1896 upon reviewing the correspondence between the U.S. and Great Britain in the negotiation process. The correspondence once again highlights the positive role of the Great Republic of the North in an issue of paramount interest to the entire hemisphere, due to its close connection with the integrity of the territories constituted as free and sovereign nations. Furthermore, having been considered by the President of the Republic and the Council of Ministers, the nature of this publication, expertly and wisely defended by the Department of State in Washington, and setting out the principles and doctrines to which Venezuela adheres in order to uphold its rights and dignity in one of the gravest issues recorded in its political annals, has led to the decision to produce a special edition in Spanish of all the notes comprising the above-mentioned correspondence, as both a pledge of recognition to the government of the United States and a welcome contribution to the promotion of principles so gallantly supported by the great people of the North in support of common security and international peace. This contemporaneous Venezuelan assessment of the role played by the U.S. demonstrates that Venezuela was manifestly content with the way Secretary of State Olney handled the treaty negotiations to that point. Venezuela thus focuses on a later stage of the negotiations between September and November 1896, during which the subjects about which it expresses most concern, the acquisition of title by prescription and preservation of the 1850 agreement, were directly addressed by Secretary of State Olney and Lord Pauncefort. Venezuela's principal contention now, as opposed to what it said contemporaneously, is that during this stage of the negotiations, the two representatives of Venezuela, Messrs. Andrade and Storo, were kept in the dark by Secretary of State Olney and denied the opportunity to defend or even explain Venezuela's interests. This is entirely fallacious. It is completely refuted by the documentary evidence, as you will now see. Far from keeping Venezuela's representatives at arm's length, on 12 September 1896, Secretary of State Olney sent Mr. Storrow an early draft of the clause on prescription, indicating he would come to meet Mr. Storrow at Mr. Storrow's home in the evening, prior to a meeting with Lord Pauncefort the following day. On your screens is a copy of Mr. Olney's message to Mr. Storrow and the enclosed treaty text on prescription. You will note the highlighted portion of the text showing a proposed prescription period of 40 years, explaining that any of the disputed territory which had been under the actual, exclusive, and continuous dominion and control of one of the parties for that period would be held to form part of the territory of that party. Mr. Storrow wrote back to Mr. Olney on 17 September 1896. Referring to their recent meeting at his home, he said, "Our views agreed the other day, so that I thought it enough to answer your telegram, no change." Mr. Storrow continued, however, by advocating for a longer period of prescription than the 40-year period initially presented by Mr. Olney. Settlements by British subjects living under British rule in territory administered solely by British rule, if long continued, will certainly, I think, give title. 60 years is the classic period. I would agree to less as a rule rather than lose an arbitration. Further down the page, Mr. Storrow also highlighted the importance to Venezuela of the 1850 agreement. I do not think that the truce of 1850 could be waived or impaired, or that it ought to be. The evidence shows that far from ignoring them, Mr. Olney received Mr. Storrow's proposals, acted upon them, and incorporated them into his own proposal to Lord Pauncefort, and he succeeded in achieving them. This is apparent from the next set of documents from October 1896, which comprise the written communications between Mr. Storrow and Mr. Olney, and between Mr. Olney and Lord Pauncefort. On these issues, prescription and the 1850 agreement, they show unmistakably that Venezuela's views were fully taken into account and advanced by Mr. Olney in his negotiations with Lord Pauncefort, and Venezuela's objectives were achieved. On the 26th of October, for example, Mr. Storrow sent Mr. Olney a revised draft of the prescription clause, accompanied by a handwritten note. It states, in reference to the number of years required for prescription to take effect, filling in the blanks with 60, I see no objection to the actual occupation part. Mr. Storrow's note continues. I will try to write a couple of sentences more and send these to your house in the afternoon. And Mr. Storrow did just that. Here is the text he sent to Mr. Olney that afternoon. The arbitrators shall adjudge a title by prescription or adverse occupation to be a good title, and shall consider 60 years as a sufficient period to establish a title by prescription. But the arbitrators may and shall, the next word is illegible, and apply all the rules of law and fact appropriate to this case, as far as they do not contravene the foregoing provision. The British position was that the prescription period should be no more than 30 years, which would have facilitated their claim of title to any of the disputed territory that they had consistently occupied since as late as 1867, 30 years before the treaty then under negotiation would enter into effect. The British proposal can be found in Venezuela's counter memorial at Annex 169. Mr. Storrow sent another note to Mr. Olney on 28 October 1896. And again, it shows the intimacy of the relationship between Venezuela's representatives and the U.S. Secretary of State. Mr. Andrade and I will come to your house at 8:15 tonight unless we hear to the contrary. The date of this meeting was propitious because the following day, 29 October, after consulting with Venezuela's two representatives the previous evening, Mr. Olney sent to Lord Pauncefort a new draft of the treaty. In respect of prescription, Mr. Olney wrote, "I cannot recede from my original suggestion as to a conventional term of prescription further than to consent to 50 years being substituted for 60. Mr. Olney explained to Lord Pauncefort that he could not agree to a shorter term than 50 years because anything less might undermine the force of the 1850 agreement, by which the parties had pledged to forego further expansion into the disputed territory. A 50-year prescription rate would preserve the 1850 agreement because it would disregard any occupation of the disputed territory that commenced after 1847, assuming again that the treaty would enter into force in 1897. By contrast, the 30-year prescription period proposed by the British, or even a 40-year period, would have conferred title on any continuous occupation commenced by 1857. And that, of course, would contravene the 1850 agreement, which is why Mr. Olney would not agree to that. As Mr. Olney explained, if a shorter term be stipulated, it is certain to be urged, and with great force, that the agreement of 1850 is thereby waived, at least pro tanto. The documentary evidence thus shows Mr. Olney's firm advocacy of Venezuela's positions on both the prescription period and on the 1850 agreement. Now, earlier in that letter, Mr. Olney explained to Lord Pauncefort that with a 50-year prescription period, there would be no need for the arbitration agreement to include an express reference to the 1850 agreement, because the 50-year prescription period would accomplish the same result, precluding recognition of any occupation of the disputed territory that commenced after 1850. In fact, the 1850 agreement had a major gap, a major lacuna, as our agent told you earlier this morning, consisting of an exchange of letters between Great Britain and Venezuela in which they each abjured any further expansion into disputed territory. They conspicuously failed to identify what or where the disputed territory was, leaving this critical term open to interpretation. Hence, Mr. Olney wrote to Lord Pauncefort, "An attempt to construe it will involve us in protracted debate and indefinitely postpone the attainment of the object we now have in view. The agreement," that's the 1850 agreement, "will come and should come before the arbitral tribunal in the natural course and will be interpreted by that tribunal by the aid of facts, documents, and considerations of which we cannot now know anything." On 30 October, Lord Pauncefort reported to his Prime Minister, Lord Salisbury, on his exchanges with Mr. Olney on these subjects. Quote, "I have tried in vain every argument and put the greatest pressure on him to obtain a further reduction," that is, in the prescription period. "He," that is Olney, "says he cannot consent in justice to Venezuela. He contends that a limit of 30 or even 40 years would nullify the agreement of 1850, to which the arbitrators must be left to give such effect as they think right, and that 50 years is the lowest period of prescription suggested by jurists and does not preclude or affect claims to the territory based on any other title." It bears emphasis that what this evidence shows is that, far from turning his back on Venezuela's representatives or concluding with the British to protect their interests rather than Venezuela's. The U.S. Secretary of State did exactly the opposite of what Venezuela has pleaded in this case. As these contemporaneous documents demonstrate, Mr. Olney took Venezuela's representatives directly into his confidence, shared drafts of the treaty text with them, received their proposals on the key issues with which Venezuela was concerned, incorporated them into his exchanges with Lord Pontefract, refused to concede any ground, in spite of what Lord Pontefract called every argument and the greatest pressure, and ultimately he delivered what Venezuela's representatives had requested: a prolonged period of prescription of 50 years and preservation of the 1850 agreement. The terms of the draft treaty were in fact agreed with the approval of Venezuela's two representatives. This is what Mr. Olney reported to Justice Brewer, then the chairman of President Cleveland's Venezuela Boundary Commission, on 10 November 1896, shortly after the conclusion of his exchanges with Lord Pontefract. The United States and Great Britain are in entire accord as to the provisions of a proposed treaty between Great Britain and Venezuela. The treaty is so eminently just and fair as respects both parties, so thoroughly protects the rights and claims of Venezuela, that I cannot conceive of it not being approved by the Venezuelan President and Congress. It is thoroughly approved by the Council of Venezuela here and by the Venezuelan minister at this capital, referring to Mr. Storrow and Minister Andrade. Mr. President, the evidence you have now seen from the contemporaneous documentary record thoroughly defeats Venezuela's challenge to the 1897 treaty, that it was somehow negotiated behind Venezuela's back without involvement of its representatives and failed to take account of its interests. There is absolutely nothing in this record to contradict Mr. Olney's statement that the treaty he negotiated with Lord Pontefract was, quote, thoroughly approved by the Council of Venezuela and by the Venezuelan minister in this capital. Mr. Olney's sense that the treaty would be approved by the President and Congress of Venezuela also proved to be spot on, as you will now see. At the very time of Mr. Olney's letter to Justice Brewer, Mr. Storrow and Mr. Andrade were en route to Caracas to obtain the Venezuela government's approval of the draft treaty. On 29 November, Mr. Storrow sent Mr. Olney a detailed report of their meetings with the President, the Foreign Minister, other government officials, and a commission of experts the government had established to analyze the treaty. Because of the report's length, 9 pages, I will show you now only the most important parts, but I think you will find it helpful to read it in its entirety, and for that reason we have included it at tab 5.2 of your folders. At page 2, the report describes the reactions of the Venezuelan president and other senior officials with whom Mr. Storrow and Mr. Andrade had met. This is Mr. Storrow writing. Mr. Andrade afterwards had a long talk with him, the president, and afterward with the Minister of Foreign Affairs and Dr. Brunal Arra, Minister of the Treasury, the strongest man in the cabinet. They were all satisfied with the treaty and said there should not be a moment's hesitation about adopting it. I have myself seen Dr. Brunal and Dr. Rojas, that's the Minister of Foreign Affairs, the latter quite frequently, and they are entirely clear on the subject. Page 4, the report describes the meeting Mr. Storrow and Mr. Andrade had with the Commission of Experts appointed to analyze the treaty and their discussion on the subject of prescription. One of the experts, Dr. Sejas, opposed on constitutional grounds any recognition by Venezuela of prescription as a source of title to territory. He was the only commission member to take this view. However, quote, Dr. Sejas finally admitted that he had no doubt prescription applied and that the arbitrators would apply it, but that to admit it in terms of the treaty would be to violate the rule of the Constitution against cessions of territory. Mr. Storrow and Mr. Andrade responded. We said it was not a concession. Prescription was, I thought, our strongest ground, and I wanted GB to agree to it, and of all possible terms, 50 years was the best for us. A week later, on 7 December, Mr. Andrade sent a telegram to Mr. Olney in which he reported this. Memorandum accepted. Will be published here Monday afternoon. Extra session of Congress will be called as soon as possible. Am authorized to sign the treaty with small exceptions, such as provisions filling vacancies in the case of death or disability. But Venezuela expect by treaty or by diplomatic correspondence through you agreement to prevent aggressive or unfriendly acts near line of contact, and also no new mine concessions shall be granted. 2 days later, Dr. Rojas, the foreign minister, wrote to Mr. Andrade indicating Venezuela's desire for other changes to the treaty, two of which he regarded as particularly important. One involved the appointment of arbitrators, which I will discuss in part 3 of my presentation. The other concerned prescription. Dr. Rojas was content with prescription as a source of title to territory, noting that, quote, Venezuela has declared itself in favor of this system. He was also content with the 50-year prescription period already included in the draft treaty. But he wanted to add to the treaty a clause requiring application of the principles of international law to territorial claims based on prescription. He proposed that the following text be inserted into the treaty. The adverse possession for 50 years referred to in Rule A must be in accordance with the principles of international law, possession in the name of the state and in the capacity of owner, public, continuous, uninterrupted, and peaceful. Dr. Rojas's letter is particularly significant because it directly and fully contradicts Venezuela's argument in the rejoinder that they were opposed to prescription as a source of title, and that Mr. Olney betrayed them and even defrauded them by agreeing with the British on a 50-year prescription rule. That argument is entirely false. At the conclusion of his letter, Dr. Rojas gave this instruction to Mr. Andrade. If, despite the efforts that are urged upon you to make, any of the stated modifications should be rejected in terms that may clear the impossibility of their acceptance, you may dispense with it in the course of the negotiations and even sign the document without the need for new consultation with this office. So determined was Venezuela to get this treaty signed. Mr. Andrade communicated Dr. Rojas's proposal to Mr. Olney in a telegram sent the following day, on 10 December. Later that month, on 28 December, after he returned to Washington, he met with Mr. Olney at his home to discuss the proposals. After the meeting, Mr. Andrade wrote this to Dr. Rojas in Caracas. Mr. Olney found all the conditions commendable, save the one regarding prescription, about which he expressed some discouragement that he deemed it superfluous, believing such an interpretation as that is one that is inconsistent with international law, to be neither possible or likely, and that without need, it would give occasion for Great Britain to delay us with a discussion lasting months or perhaps years from which no benefit would ultimately result. Mr. Andrade, to whom Venezuela granted full powers to sign the treaty, then described how he responded to Mr. Olney. I hinted that if such were his view, I would not insist upon submitting the aforementioned clarification to the British ambassador. And with a nod unmistakable in its meaning, he approved of such disposition. To conclude part two of this presentation, it is crystal clear that Venezuela has no legal or evidential basis, none whatsoever, to argue that the 1897 treaty is invalid on grounds that the United States failed to consult with Venezuela during negotiation of the treaty, or that it colluded with Britain behind Venezuela's back, or that it accepted terms that favored British interest to the prejudice of those of Venezuela. The evidence makes clear that the United States did not contravene Venezuela's position on prescription, which was duly reflected in the treaty's final text, or on the continuing validity of the 1850 agreement. In both cases, the United States so. I turn to part three, which I can cover much more quickly. In its written pleadings, Venezuela challenges the validity of the 1897 treaty on the ground that without its consent, the treaty excluded the appointment of any Venezuelan arbitrators. This, too, is a groundless argument, again, completely defeated by the contemporaneous evidence. The draft treaty delivered to Caracas in November 1896 addressed the appointment of arbitrators in Article 2. It provided for a tribunal of 5 members, 2 to be nominated by the judges of the Supreme Court of the United States, 2 to be nominated by the British High Court of Justice, and the 5th to be appointed by the 4 so nominated. This left open the possibility that a Venezuelan could be appointed to the tribunal by the U.S. justices, a possibility of which the British were quite aware and quite uncomfortable. On 8 December 1896, Lord Ponsford wrote to his prime minister that he was a little uneasy whether the U.S. judges may not be urged by Mr. Olney to appoint a Venezuelan as arbitrator because, quote, "we know of no Venezuelan jurist worthy of the name or whom we could consent to entrust with the function of arbitrator in such a case." This statement is certainly offensive to us as well as to Venezuela. We call attention to it only to underscore the adamance of Britain's stance on the clause regarding appointment of arbitrators. Understandably, Venezuela bristled at Lord Ponsford's dismissive view of its desire to appoint one of its nationals to the arbitral tribunal. On 10 December, Venezuela's representative, Mr. Storrow, cabled Mr. Olney from Caracas that, quote, "treaty stands accepted as cabled, but there are sharp attacks about the appointment of arbitrators and cabinet very desirous have one Venezuelan on the tribunal. This would help much with public and Congress." Mr. Olney duly transmitted Mr. Storrow's message to Lord Ponsford the next day. The day after that, on 12 December, Lord Ponsford responded to Mr. Olney, rejecting Venezuela's request. In his words, quote, "it would be a most dangerous departure from the long-established practice of international arbitration. The very reason for taking the nomination of the arbitrators on the side of Venezuela out of the hands of the Venezuelan government and confiding that duty to 2 judges of the Supreme Court was that the latter should appoint arbitrators of U.S. nationality." Faced with this British rejection, Mr. Olney sent a telegram to Mr. Storrow informing him that matter closed between Great Britain and United States. Changes treaty must be made between Great Britain and Venezuela. And that is precisely what happened. On 28 December, Mr. Andrade, having returned to Washington from Caracas, met first with Mr. Olney and then directly with Lord Ponsford. And they reached an agreement on the appointment of arbitrators, an agreement reached by Mr. Andrade with Lord Ponsford, his British counterpart. As recorded in Mr. Andrade's report to Dr. Rojas of 9 January 1897, he, Mr. Andrade, and Lord Pauncefort agreed that Article 2 of the treaty would be revised to attribute to Venezuela the appointment of only one of the arbitrators on her side and the other to the United States, it being noted that the Venezuelan appointee would be a judge from the Supreme Court of this country, the United States. Mr. Andrade added that he considered this agreement beneficial to Venezuela. The more I think of it, the more I think that Venezuela, far from wishing to restrict the participation of the United States in the composition of the tribunal, should seek to augment it. The Venezuelan government agreed to the arrangement negotiated by Mr. Andrade and Lord Pauncefort, and it decided to exercise its right of appointment by nominating the Chief Justice of the U.S. Supreme Court, Melville Fuller. This meant that Venezuela would be represented on the tribunal by 2 U.S. Supreme Court justices, since it had already been decided that the other representative would be Justice David Brewer, the same Justice David Brewer who was serving as the chairman of President Cleveland's Venezuela Boundary Commission. Mr. Storrow, Venezuela's counsel, considered that this solution gave Venezuela exactly what it wanted. On 26 January, he wrote to Foreign Minister Rojas, quote, "I think you have got what you desired, a clear and formal appointing power of Venezuela on the face of the treaty, precisely the same to juris whom at Caracas you told me you preferred." President Crespo also regarded this as a win for Venezuela. In his address of 20 February 1897, he emphasized, quote, "The government deemed it indispensable to introduce into the treaty a modification aimed at ensuring the appointment of the arbitral tribunal with the effective participation of the Venezuelan authorities. This proposal was promptly submitted and the arbitration was accepted." Plainly, there was no fraud or error in regard to the agreement on appointment of the arbitrators. Venezuela was fully informed of the draft treaty text, the subsequent exchanges between Mr. Olney and Lord Pauncefort, and the necessity of direct negotiations between Venezuela and Great Britain to resolve the issue. And those negotiations resulted in an agreement with which Venezuela professed its satisfaction. These indisputable facts doom Venezuela's challenge to the validity of the 1897 treaty based on the appointment of arbitrators. I come to part 4, the final part of my presentation concerning, and this concerns Venezuela's claim that it agreed to the 1897 treaty under coercion, as prohibited by Article 52 of the 1969 Vienna Convention. It will take me even less time to dispense with this argument. In the first place, Article 52 of the 1969 Convention has no retroactive application. As the ILC commented, quote, "The Commission considered that there is no question of the article having retroactive effects on the validity of treaties concluded prior to the establishment of the modern law." In 1897, customary international law did not recognize coercion as a basis for invalidating a treaty. For the legal discussion, I refer the Court to Guyana's reply at paragraphs 2.102 to 2.110. But even if there were such a rule in 1897 quad non, what coercion is Venezuela talking about? How was it coerced into signing the 1897 treaty, and by whom? There is absolutely no evidence that Mr. Olney or President Cleveland or the United States coerced Venezuela in any way. The evidence is all to the contrary, particularly as Mr. Olney wrote to Justice Brewer both of Venezuela's representatives, Mr. Andrade and Mr. Storo, were fully satisfied with the draft treaty that had been negotiated. In February 1897, in submitting the treaty to the Venezuelan Congress for ratification, President Crespo himself made clear that Venezuela was not coerced into signing the treaty. These are his words. The settlement plan was presented to Venezuela for its consideration with no coercive intent and in full respect of the sovereignty and independence of the Republic. How can they say they were coerced? The official yearbook published by Venezuela's foreign ministry for 1897 declared that the final terms of the treaty demonstrated that, quote, the government has neither paused nor spared any effort in the task of safeguarding the territorial integrity of the Republic. And it included this statement by the foreign minister expressing gratitude to the United States for its support in the treaty negotiations. Allow me to express my conviction that the foundations of this treaty represent, on the part of the United States, a noble and eminent effort for the sake of continental peace. These terms alone will serve as an enduring reminder for Venezuela of the interest with which its powerful sister nation sought to reconcile it with the great British nation in a dispute lasting more than half a century, marked by bitter incidents and perilous situations. Faced with this contemporaneous documentary evidence, how can Venezuela, in the present case, possibly argue that it was coerced to accept the treaty? In fact, it fails to identify any acts of coercion against it or any persons or entities who might have perpetrated such acts. Instead, it complains of what it calls, quote, structural coercion. In Venezuela's telling, it found itself in a situation in which it had no choice but to accept arbitration of its territorial dispute with Great Britain, because the alternative would have been to subject itself to further British expansion, which it was powerless to stop. But in making this argument, Venezuela conveniently forgets or deliberately ignores the fact that it had been pleading for precisely this outcome, an arbitration agreement with Great Britain, for the better part of 2 decades, that it repeatedly beseeched the United States to come to its assistance and to press the British to accept arbitration of the territorial dispute. That under U.S. pressure, the British finally agreed, and that the treaty negotiated by the U.S. in close consultation with Venezuela's representatives was deemed by Venezuela to be acceptable and worthy of signature. Venezuela's very belated contention, 66 years after the fact, that it was coerced into signing the treaty, physically or structurally, has no factual support. It is completely contradicted by the evidence before you. The bottom line, Mr. President, is that Venezuela cannot come up with any basis, any legitimate basis whatsoever, for invalidating the 1897 treaty, or for invalidating the 1899 arbitral award on the basis of an allegedly invalid compromis. This afternoon, my colleagues will demonstrate convincingly that there are no other bases for invalidating the 1899 award or the international boundary that resulted from it, and that the award was and remains valid and binding on both Venezuela and Guyana. Mr. President, members of the Court, I thank you for your kind courtesy and patient attention. This concludes Guyana's submissions in this session. We wish you a pleasant lunch.
Rendered with very little or no reasoning, the President of the Tribunal that rendered the sentence, which is a subject of the matter which is a dispute before the court, Frederick Fromhold Martin, and his co-arbitrators were profoundly steeped in these practices in which one could barely notice any customary rules apart from the binding nature of the award. And it is in that context that this award was rendered. And this must be borne in mind because the validity of this award must be assessed in the light of the contemporaneous law. It's the basic axiom of law, such as Max Huber described in his famous Palm Island Award. And this principle had already been applied in previous awards and has been done again in more recent decisions. A juridical fact must be appreciated in the light of the law contemporary with it and not of the law in force at the time when the dispute in regard to it arises or falls to be settled. End of quote. And it is in light of this principle that one must assess the 7 grounds of invalidity of the sentence that Venezuela mentions in chapter 5 of its rejoinder with vehemence and frivolity. And you can see on your screens, Mr. Reichler demonstrated this morning the futility of the first of these reasons based on purported invalidity of the 1897 compromise. As to the award itself, I find it somewhat difficult to understand how one can respond separately to Venezuela's claims made in Section D and under paragraphs 1, 2, and 5 of Section E. Given that the arbitrators did not state their reasoning and were under no obligation to do so, the answer to these 3 objections is necessarily in the response to the answer to question E4. It is from the procedure it followed. It is through the deliberations that took place between the members and the attention that the members paid to the pleadings of the parties that one can infer that the tribunal fully complied with its mandate. As to ground E3, I feel like some kind of every battle here. As to E3, I will briefly demonstrate in my conclusion that the tribunal did not rule ultra petita. Venezuela believes in lack of grounds, a sufficient reason for invalidity and nullity. It is indeed tiresome to have to repeat this because the rejoinder provides nothing new, but there can be no doubt neither the text of the compromise nor any customary rule require that reasons be given. It is clear that contrary to other compromises concluded at the same time or earlier, the Treaty of Washington, whose provisions are, as Venezuela insists, precise and detailed with regard to the substance of the dispute and the procedure to be followed, it does not contain any provision requiring the tribunal to motivate its award. Venezuela, nevertheless, attempts to infer from this obligation some, and I quote, a certain number of features characterizing it that fail to be convincing. Okay, the composition of the tribunal, yes, it is made up of lawyers. And if it is true that more awards rendered at the end of the 19th century by joint commissions were reasoned, not all of them, but more of them were reasoned than those rendered by heads of state, it is impossible to infer from this that there was a customary obligation from this inconsistent practice. Then there's the issue of the time limit of the award. This clause was mechanically copied on those that are identical and found in the compromise between the US and the UK in 1871 in the Halifax case, or the compromise of 1892 between the United States and Venezuela, which provides for the submission of claims by the Venezuela Steam Transportation Company to the Joint Commission between Venezuela and the United States. It therefore seems highly risky to draw any conclusion whatsoever, particularly since this time frame was merely indicative. But the supposed ulterior motives of the tribunal are immaterial, given that the tribunal's working methods enabled it to fulfill its mandate. The precision of the task entrusted to the arbitrators, I'll come back to it, but for now it is sufficient to note that despite the precision of the description of the task entrusted to the tribunal in general terms, and more specifically in Articles 3 and 4, the obligation to state reasons is precisely, despite it being so precise, the reasons are not included. The obligation to state reasons is not included. And that said, I would like to note in passing the guidelines that are set out as shown in the highlighted extracts of Article 4 of the compromise that is on the screen. And I would like to draw your attention in particular to the final clause that combines in the same sentence reason, justice, principles of international law, and considerations of equity that was specific to the case. In the absence of any relevant treaty provision, Venezuela asserts that the tribunal should have motivated its award under customary law. I quote, under international law applicable at the time, this is Venezuela speaking, not me, under international law applicable at the time, arbitrators were under a general duty to state the reasons for the award. I would like to note in passing that Venezuela acknowledges that it was indeed at the time when the award was rendered that one has to put oneself, or perhaps even in 1897 when the compromise was signed. We agree on this point, but we certainly do not agree on the content of customary law or even on its very existence. Previous practice, as that our opponents disregard totally, was partial and inconsistent, and the obligation to provide reasons was certainly not accepted as law. Unable to establish the existence of this practice during the 19th century, Venezuela invokes the practice of the following century. This is indeed a strange concept to use an ex post practice as demonstration. The crux of Venezuela's demonstration reads, and I quote, in sum, the 1899 arbitral award was rendered at a time when the duty to state the reason for an award was widely recognized by states, largely recognized or widely recognized by states, and on the basis of an arbitration treaty which, because of its specific features, clearly created an expectation that the tribunal would provide reasons for its decision. Now, I'm not going to criticize my opponent's prose, but I cannot help but admire the relative caution in this statement. The duty to state reasons was largely recognized, and the circumstances of the case gave rise to an expectation that the tribunal would state reasons. This is far from a categorical assertion, and rightly so. It is clear that no practice that was sufficiently widespread and representative as well as consistent, likely to establish the existence of a customary rule, can be identified at the critical date. And it is even more true with regards to opinio juris. The 3rd of October 1899 award was at the time far from being an isolated case. You will find in your folders under tab 6.1 a non-exhaustive list of awards that were without reasons or whose reasons were reduced to almost nothing. This list confirms the observation that Charles Rousseau made, that the reasoning was only established late in international arbitration procedures. And to counter these numerous precedents, Venezuela argues that some are very old. It is indeed true, and that is all the more significant. They preceded the 1899 award and thus set the tone and inspired subsequent practice. Then it says that these precedents stem in part of heads of states of third countries whose reasons for not stating reasons may have been specific. This might also be true, but they nonetheless form part of a practice that was accepted at the time as law, from which it followed that motivation of awards, however useful or desirable they might be, was by no means a condition of validity of the award. Venezuela notes that in some cases, compromises called upon tribunals to decide in accordance with principles of justice and equity. Maybe. But before the adoption of the PCIJ statutes and the travaux préparatoires, the separation between principles and international law was not rigid. The text of Article 4 of the 1897 Compromis and the wording of several others blending these different sources in one common statement bear witness to this indecision and this permeability. Venezuela again says among the awards that were mentioned that some of them should be excluded from the list because they were allegedly reasoned. On reading them, members of the court, you cannot but agree that the reasoning was reduced to its simplest expression. Venezuela also notes that some compromise expressly provided that arbitrators were not asked to provide the reasons for the decisions. This is inaccurate for some of the cases that Venezuela mentions, and one can conclude, on the contrary, that the absence of such precise statements, that reasoning, or providing reasoning, was not mandatory. Similarly, the fact that other previous compromise provided expressly that the tribunal should state its reasons must be interpreted as meaning that this was far from being self-evident. It is true that Venezuela seems to trace the obligation to state reasons to the draft rules that were adopted in 1875 by the Institute of International Law. This text was rather innovative at the time and applies exactly the opposite as what our opponents wish to infer. It is not a question of codification, which would have been merely doctrinal in any case. It would have been a customary norm, but in fact it is a wish that was made by the Institute as a kind of recommendation addressed to states. In its preamble, the Institute said, and I quote, "Desiring that recourse to arbitration for the settlement of international disputes be resorted to more and more by civilized peoples, hopes to be of service toward the realization of such progress by proposing for arbitral tribunals the following eventual regulations. It recommends them for adoption in whole or in part to states that may conclude compromis." Article 23 provides that the arbitral award must be reduced to writing and contain a statement of reasons unless that is dispensed with under the stipulations of the compromis. And most importantly, under Article 24, the award with the reasons if stated, that is to say that they may not be stated, is notified to each party, which indicates clearly that the Institute does not rule out the possibility of unreasoned awards, even if it recommended that it should be done. And as it was written a few years later, the draft of the Institute was a draft to be consulted. It was a possible rule. Mr. President, I do not claim that it existed before the 1899 award, that before the award there was a norm that existed excluding reasoning from arbitral awards, because it would be contrary to the very idea of the basis of our arbitral institution, which is the autonomy of the will of the contracting parties. What these precedents clearly show is that there wasn't another customary rule either imposing that the award be reasoned, making the absence of reasoning a cause of nullity. To take shape, to determine the existence and content of a rule of customary international law, it is necessary to ascertain whether there is a general practice that is accepted as law, opinio juris. Such a practice didn't exist in 1899, and a fortiori, it was obviously not accepted as law. It is only later on that it crystallized into a customary obligation. In fact, Venezuela doesn't insist, and it quickly abandons the line of reasoning based on the 1875 rule by quoting Kasberg that the obligation to state reasons was definitively enshrined in positive international law by virtue of Article 52 of the 1899 Convention for the Convention for Peaceful Settlement of International Conflicts. This implies, on the contrary, that this norm didn't pre-exist the convention. It may be noted that with one exception, positive law, that is being referred to here, is purely conventional. This exception, because there is an exception which is retroactive, dates from over 60 years before, 60 years earlier, after the award rendered by the King of Spain. Absence of motivation in an award is a cause of nullity. As my colleague Nilufer Oral will show later on, the court didn't say any such thing. As to Article 52 of the Institute's rules, the award given by majority votes is accompanied by a statement of reasons, but it is always a progressive text looking to the future and does not claim to codify any existent rule. In fact, Kasberg immediately adds, pertaining to the Cleveland Award in the Cerruti affair, a Cerruti case, that when the award was rendered, it is to say in 1897, one couldn't establish that positive international law stated that arbitral awards should be motivated. In the wake of this first argument, which backfired on it, Venezuela invoked another one, which was just as ill-advised. The assertion of Augusto Pierantoni, according to which, and I quote, the grounds of fact and law, whilst they are a guarantee required by procedural law, are a requirement of international society. This quote is taken from a consultation drafted by this Italian lawyer at the request of the Colombian government, unhappy with the solution retained by President Cleveland in the Cerruti case. It is a pro domo argument in favor of the advantages of arbitration as it should be practiced, according to him. And it is not a demonstration of the existence of a positive law norm requiring reasoning and making the absence of reasoning a cause of nullity. This award was then revised, but for it to be revised, the two states had to reach a new compromise. As to the travaux préparatoires of the Hague Convention of 1899, even though it shows that the position of Martins was opposed to the treaty principle, it was, if not marginal, at least in the minority. There was a vote. But the delegates of the conference did not consider that the statement of reasons was already an obligation enshrined in positive law. Rather, that in the eyes of the majority, it was highly desirable. And that was a position that Martins shared as well, in principle. The award, which is the subject matter of the dispute, was not reasoned because it was not necessary neither under the 1897 treaty nor under customary law. There was nothing scandalous or unusual or unlawful about it. Respected members of the court, do you think that it is useful to open the door to challenge awards without statements of reasons rendered in the 19th century? Do you think it is advisable to open these cases again and have the parties that have lost to come before the court 100 years later to seek retrials. I'm not convinced that that would be a good idea. In Section E of Chapter 5 of its rejoinder, Venezuela alleges that the arbitral tribunal committed 5 other breaches that constitute grounds of nullity on the basis of abuse of power. These are essentially direct consequences of the absence of reasoning and are so dismissed on that ground. I shall analyze them, distinguishing between those that amount to the tribunal being accused of failing to respect the compromise by not exercising the jurisdiction conferred on it, and the third, which, on the contrary, consists in criticizing it for having gone beyond ultra petita.
Mr. President, the tribunal exercised its jurisdiction in accordance with its statute. Article 3 of the Treaty of Washington fixes the subject matter of the dispute. Article 4 specifies how the latter should be settled. Pursuant to Article 3, the arbitrators investigated and ascertained the extent of the territories belonging to or that might lawfully be claimed by the United Netherlands or by the Kingdom of Spain, respectively, at the time of the acquisition by Great Britain of the colony of British Guyana. To that end, the arbitrators explained that they had duly heard and considered the oral and written arguments of the Council representing, respectively, Her Majesty the Queen and the United States of Venezuela, and have impartially and carefully examined the questions laid before them. That's precisely what they did, and I'll come back to that in a moment. As to claiming that the tribunal provided or should have provided a separate answer to the part of the question concerning the extent of the territory on the one hand and the determination of the boundary line on the other, I remember that a young lawyer in 1986 had tried to convince the chamber of the court constituted in the case Burkina Faso versus Mali of the merit of the distinction, but to no avail. Not without common sense, the chamber considered, and I quote, that the effect of any judicial decision rendered either in a dispute as to attribution of territory or in a delimitation dispute is necessarily to establish a frontier. In support of its accusation of misuse of power, Venezuela relies on a decision of the ICSID ad hoc committee in the 𝐏𝐚𝐬 case handed down in 1985 to assert that tribunals are not called on merely postulating the existence of a principle without demonstrating it. This reasoning is anachronistic and amounts to criticizing the 1899 award of not stating reasons, although, as I pointed out, it didn't have to. Venezuela's reasoning, if we can call it that, reminds me of those nursery rhymes whose last verse refers to the first. The award doesn't state reasons. Venezuela claims that it is invalid because it does not state reasons. It's impossible to prove because it is invalid, because it is devoid of any statements, etc. Mr. President, instead of discussing the legal arguments presented by the parties, the arbitrators, as Venezuela wrote, rushed to a decision and saw fit to resolve the various complex legal issues in the space of less than 6 days before pronouncing its unreasoned award on midday of 3rd of October 1899. Rather than the award itself, the transcripts of the hearings held in 1899 and the written testimonies of the members of the court relating to the conduct of the proceedings and deliberations show that the attention paid by the arbitrators was to the titles claimed by both states. And as Venezuela insists, deliberations amongst the arbitrators occurred After the filing of lengthy memorials and the presentation of oral pleadings of parties in a lengthy legal contest comprising 56 sessions running to 3,200 pages of transcript. During those long days spent listening to both the legal and factual arguments adduced by the parties, in full compliance with the adversarial principle, the arbitrators had ample time to share their impressions on this subject and did so. The communication between the 5 members of the tribunal related in a letter from Lord Russell to Lord Salisbury on the 7th of October 1899, which is summarized in paragraph 8.44 of our memorial, are a perfect illustration inter alia of the existence and serious nature of these deliberations. A lot of other evidence in the case file relating to the conduct of the hearings fully confirms that the tribunal faithfully applied the compromis. The arbitrators questioned parties on both legal and factual aspects of the case on several occasions during the hearings. For example, on the application of the rules agreed in Article 4 of the compromis, on the Dutch and Spanish activities in the disputed zone, on the critical date, on the territorial title, or the 50-year prescription. The case file also shows that Martins was very much eager to ensure the adoption of a unanimous award. This desire, which Venezuela criticized, in fact didn't have anything reprehensible. On the 21st of October 1899, Martins wrote in his journal that he considered, and I quote, that he had not only had the right, but a moral duty to carry out such negotiations to ensure full unanimity between the arbitrators and to achieve the greatest objective, a unanimous arbitral award. However, and this is important, he nonetheless did not sacrifice the fundamental principles governing arbitral proceedings. After having formed his own opinion on the facts and applicable law, he sought the approval of his colleagues. Martin's journal, the interview of Judge Brewer, one of the American arbitrators appointed by Venezuela, published in the New York Times of the 5th of October 1899, confirm that this was indeed what happened. For want of time, I cannot comment in detail the relevant pages of these 2 documents, but they're extremely significant. We've included them in the judges' folders. They appear in tab 6.2 and 6.3. With your permission, members of the court, I would like to urge you to read them carefully. These extracts show that each of the arbitrators formed their own legal opinion and that they subsequently subscribed to the solution put forward by the president, somewhat grudgingly when it came to the 2 British members of the tribunal, who can qualify as belonging to the minority. Yet they all signed the award without protesting, and the work of the tribunal, moreover, was welcomed during the last days of the hearings by Mr. Harrison, lead counsel of the Venezuelan party, who congratulate the tribunal for having, and I quote, laboriously gone through this long historical inquiry and traced the title of the Netherlands and the title of Spain down to 1814. These very same arguments refute the argument which Venezuela seeks to base on a violation of Article 5 of the compromis, which provides that arbitrators shall undertake an impartial and careful consideration of the questions submitted to them. By basing themselves on these 2 letters, Venezuela contends that counsel appointed by Great Britain allegedly communicated unlawfully with the British arbitrators. Here again, Venezuela persists in ignoring 2 centuries of the evolution of international arbitration, which in 1899 was still influenced by the practice of diplomatic negotiations. This is made evident by the fact that Venezuelan counsel met the arbitrators appointed by Venezuela at the end of the hearing and before the issuance of the award. Today, such secret meetings would admittedly be frowned upon, without necessarily, moreover, leading to an annulment of the award. But of course, we're talking about 1899. I would now like to focus on the last argument put forward by Venezuela to substantiate its accusation of excess of power, according to which the tribunal acted inconsistently with the scope of its powers by deciding matters falling outside of its competence. In other words, it would allegedly have ruled ultra petita. May I say forthwith, we're fully aware of the fact that a tribunal has the duty to answer requests of the parties as they are worded in the compromis, and that's indeed what was done in the award, but also to refrain from ruling on points which are not included in the requests. But in that respect as well, the Martins Tribunal fulfilled the requirements of arbitration law. That holds true whether it's a question of the alleged infringement of Brazil's rights or the regime governing the Amacuru and Barima rivers. President Venezuela reads into an award an alleged prejudice to Brazil's rights. That is not the case. It suffices to read the single paragraph where reference is made to Brazil to realize that the tribunal does not rule on that country's rights, but on the contrary, takes care to preserve them. The delimitation line, provided in the award shall be subject and without prejudice to any questions now existing or which may arise to be determined between the government of Her Britannic Majesty and the Republic of Brazil, or between the latter republic and the United States of Venezuela. The tribunal could not have been any clearer. It did not wish to adjudicate, and it did not adjudicate on Brazil's rights. Secondly, although the tribunal determined the boundary between Brazil and British Guyana, that was not prejudicial to either Brazil or Venezuela's rights. As regards Brazil, it was not a party to the proceedings, and the award, as far as it was concerned, was res inter alios acta. As regards Venezuela's rights, they were fully complied with, and besides, it does not claim otherwise. The few relevant points made in its written submissions in that regard concerned the purported infringement of Brazil's rights and not its own. Therefore, no cause of action. Thirdly, the award of the Italian King Victor Emmanuel II, rendered in 1904, pursuant to the to the Treaty of the 6th of November 1901 between Great Britain and Venezuela, explicitly, moreover, recognized that the 1899 award cannot be cited against Brazil, which was unaffected by that judgment. Furthermore, subsequently, in the years 1920, the three states entered into a series of treaties specifying the delimitation of their respective boundaries, and in 1932 they definitively fixed the triple junction point of the line determined in the 1899 award in accordance with Venezuela's own request. And Professor Oral will revert to that in a moment. Mr. President, Venezuela also alleges that the tribunal exceeded its jurisdiction by fixing regime of freedom of navigation on the Amacuru and Barima rivers, both tributaries of the Orinoco. The relevant passage is projected on the screen. It means that in time of peace, both rivers are open to navigation by the merchant ships of all nations in exchange for payment of fees and customs duties. Both rivers, the Amacuru and the Barima, have always played an essential role for transport and trade between peoples on both sides of the border because they were the only means of having access to the sea. According to our opponents, the treaty did not empower the tribunal to rule on the navigation regime governing these two watercourses, and it's true that the compromis did not explicitly require the arbitrators to adjust the said regime. But Rule C, laid down in Article 4, impels them to adjust the border regime because in determining the boundary line, if territory of one party be found by the tribunal to have been the date of this treaty in the occupation of the subjects or citizens of the other party, such effect shall be given to such occupation as reason, justice, the principles of international law, and the equities of the case shall, in the opinion of the tribunal, require. Of course, here it's not a question of changing the boundary, but modifying in equity the negative human effects that its determination might entail. Besides, that was specifically the position adopted by Venezuela itself in its written pleadings of the 1st of November 1898 before the arbitral tribunal. This would have warranted a lengthy citation. A small extract is projected on the screen. I don't know whether you can read it, but I have little time. And once again, members of the court, I would like to refer you to the pleadings of Venezuela's counsel. We have provided other extracts to be found in tab 6.4 of your folders, and that is precisely what we are arguing today. The adjustment contemplated in Article 4, Rule C of the compromis occurs subsequent to the fixing of the boundary, not as a change of its line, but to mitigate any disadvantages which might ensue for the riverside nationals on either state. And as Venezuela's counsel also wrote in 1898, and I quote, it is not stated by the treaty what form of adjustment, if any, is to be adopted by the arbitrators in carrying out the provisions of Rule C. The whole matter is left to their judgment and discretion. End of quote. In its rejoinder, Venezuela backtracks and attempts to downplay this interpretation, which is nonetheless undeniable. It asserts that this provision provided for possible adjustments to the boundary line having regard to specific factors. That is clearly false, as Venezuela, Mr. President, as Venezuela observed in its pleadings of 1898, once this determination made, and there is no question here of changing it, but merely to draw conclusions, the question would then arise how, with the greatest fairness both to the state in whose territory such settlers were found and to the settlers themselves, an adjustment should be made of the relations between the two, and it was accordingly provided in the treaty that the treaty should itself finally adjust. End of quote of the Venezuelan pleadings. This in fact does not concern the boundary, but the relations between the two states, and should occur to the benefit of the inhabitants. And that's precisely what was done by the arbitrators by providing for a special navigation regime over the waters of both rivers in the interest of the nationals of the two parties. Furthermore, even if the compromis had not set out a rule, nothing would have prevented the tribunal from undertaking such an adjustment in the interest of the said inhabitants. In paragraph 5104 of its rejoinder, Venezuela finds itself once again trapped in a vicious cycle. The award does not make it clear at all whether the provisions have been complied with, and thus it is impossible to determine whether the tribunal acted in compliance with its mandate, and accordingly the award is null and void on grounds of excess of power. We're back to the endless nursery rhymes. But we can, in fact, find a solution, members of the court. The award does not state any reasons because the compromis does not impose that. When it was rendered, there was no unwritten rule requiring it. And in the instant case, the detailed file submitted to the court undeniably makes it possible to ensure the validity of the 1899 award when it was pronounced. It is therefore undeniable that the tribunal remained within the limits of its jurisdiction, resolving as much as possible the controversy which had been submitted to it. And with your permission, would you be so kind as to give the floor to my colleague, Mr. President, Professor Niloufer Oral, who will, in fact, demonstrate that these conclusions are all the more unavoidable in that Venezuela welcomed the award when it was pronounced, and in fact waited 60 years before dealing with the alleged invalidity. Thank you for your attention. I thank Professor Pelé.
Niloufer Oral, Madame, you have the floor.
Mr. President, distinguished members of the court, it is a great honor for me to appear on behalf of the Cooperative Republic of Guyana in these proceedings. Today, I will address the 6 decades of conduct by Venezuela, during which it freely accepted the validity of and meticulously complied with the 1899 arbitration award and the boundary established by the 1905 boundary agreement. Mr. President, my presentation will be in 2 parts. In part 1, starting in 1899 through the early 1960s, a period spanning more than 60 years, I will present the numerous instances of Venezuela's constant and fully given acceptance of and compliance with the award. There were no deviations, not a single one throughout this period. In part 2, I will address the legal effects of this prolonged acceptance and acquiescence to the 1899 award and the 1905 boundary agreement. Mr. President, I will now take us back in time and provide overwhelming evidence that between 1899 and 1962, Venezuela accepted and recognized the legal validity of the arbitration award. Indeed, at times, Venezuela insisted that the award be implemented to the letter, and no matter how minor, refused to accept any alterations to the boundary as determined by the award. Venezuela accepted the award as valid and binding from the moment it was issued on 3rd of October, 1899. Venezuela celebrated the result as a victory, at least in part, because Venezuela had acquired the most valuable part of the disputed territory, the mouth of the Orinoco River with the territory on both banks. This gave Venezuela control over the largest and most strategically and commercially important river on the north coast of South America. Venezuela's success and the importance of the area were underscored by its counsel, former U.S. President Harrison and his co-counsel, Mr. Mallet Prévost, in statements published by The Times on 4 October 1899, the day after the award was issued. I quote, Within the Schomburg line lay the Amacuro River and Point Barima, the latter forming the southern entrance to the great mouth of the Orinoco. No portion of the entire territory possessed more strategic value than this, both from a commercial and a military standpoint, and its possession by Great Britain was most jealously guarded. Council continued highlighting the territory that the British had lost. This in no way expressed the extent of Venezuela's victory. Great Britain had put forth a claim to more than 30,000 square miles of territory west of the Schomburg line. And it was this territory which in 1890, Great Britain was disposed to submit to arbitration. Every foot of this territory had been awarded to Venezuela. Venezuela's agent in the arbitration, Dr. Jose Rojas, agreed with his counsel's assessment in a telegram to the foreign minister. That telegram is preserved and quoted in a message dated 7 October 1899 from Venezuelan ambassador Jose Andrade and states the following. Sentence of tribunal. England gives up Point Barima and the coast until Point Playa. From thence the line goes until Schomburg's line, which it follows until the junction of the Cuyuni and Wanamo. This gives us 5,000 square miles east of the Schomburg line. Arbiters and counsel for Venezuela were brilliant. The reference to Point Barima and the coastline west of Point Playa shows the great importance that both parties attached to this territory. This was equally voiced by Ambassador Jose Andrade's letter of 7 October 1899, who in glowing words said, "Greatly indeed did justice shine forth when in the determined A press article from Nouvelles de l'Étranger quoted similar satisfaction with the award from the president of Venezuela, Mr. Ignacio Andrade, dated 11 October 1899, saying, "The award was a source of satisfaction for the country as international justice had returned a part of its territory that had been usurped and vindicated its right." While Venezuela's reaction to the 1899 award included some disappointment at not receiving a greater share of the disputed territory, this does not equate to challenging the award as being invalid or void. Venezuela never challenged the legality or the validity of the 1899 arbitral award for the next 62 years. Venezuela's failure to challenge the legality of the award for 62 years is especially prejudicial to its current claim that the award is invalid. Each and every one of the challenges to the award Venezuela now makes in these proceedings were available to it since October 1899. Yet, during the next 6 decades, Venezuela did not make any of these claims. Let's take them one at a time, as they appear in Venezuela's rejoinder. The first reason invoked for the award's alleged invalidity is, quote, that it was rendered on the basis of an invalid treaty. Mr. Reichler showed you this morning that Venezuela's arguments against the validity of the 1897 Treaty of Washington are entirely unsustainable. Venezuela could not help but be aware of each of these alleged deficiencies in the treaty at the time it was being negotiated, agreed, and ratified. Yet, neither in 1897 nor in 1899 did Venezuela give voice to any of these allegations, nor did it do so for another 60 plus years. Second, Venezuela argues that the award is invalid, quote, because the tribunal failed to state the reasons on which it was based. Professor Pillay has amply demonstrated that this is not a valid basis for challenging an arbitral award issued in 1899. This point is also raised in a very telling report dated 4th of May, 1900, exactly 126 years ago from today, prepared by Dr. Rafael Cejas. Dr. Cejas, an international lawyer and former foreign minister who was also a member of the committee tasked with examining the wording of the 1897 treaty, which conferred jurisdiction on the court, in fact expressly advised Venezuela that there were no grounds for challenging the award, including the absence of reasons. Plainly and clearly, Venezuela knew in 1899, at the moment of issue, that the award did not include a statement of reasons. Yet Venezuela chose not to complain about this or challenge the award on that basis for over 60 years. Third, Venezuela argues that the arbitral tribunal manifestly exceeded its power, in particular by failing to respond to all the questions put to it, failing to apply the applicable law, deciding matters outside the scope of its competence, failing to act impartially, and failing to issue a decision based on law. Here again, Professor Pillay addressed these issues. Importantly, for present purposes, all these alleged shortcomings of the award would have been obvious to Venezuela upon its first reading. And the facts show that for the next 6 decades, none was invoked as a basis for challenging the award. Venezuela argues in these proceedings that it only first acquired evidence of the purported legal defects in the 1899 award after 1949 publication of the Mallet-Prevost Memorandum. This is plainly untrue. It is entirely contradicted by the evidence. Every one of the challenges Venezuela now makes to the validity of the award is based on facts that were known to Venezuela at the time the award was issued in October 1899 or very shortly thereafter. One example among many that could be offered, on 22 October 1900, Venezuela's Minister of Foreign Affairs wrote to Venezuela's Commissioner on the Joint Boundary Commission that the 1899 award was, quote, more the result of a compromise than of an essentially judicial examination, end quote, and that the boundary established by the award was, quote, a line de facto determined without any support or reason. That was more than 61 years before Venezuela first challenged the award on these grounds. Mr. President, Venezuela did more than to fail to protest or challenge the validity of the 1899 award. In fact, it positively endorsed the award and insisted on strict compliance with it. As much as Venezuela would like to discount the relevance of its conduct during the 5-year demarcation period between 1900 and 1905 as merely a technical exercise, the 1905 agreement is a legally binding treaty that represents years of collaborative hard work between the representatives of British Guyana and Venezuela, which Venezuela willingly and freely signed. As detailed in Guyana's pleading, soon after the delivery of the 1899 award, Venezuela and Great Britain established a joint boundary commission. Now today, more than 1 century later, Venezuela would have us believe that it was coerced into participating in the boundary demarcation by Great Britain. The evidence offered is that Great Britain refused Venezuela's request to delay the start of the work, responding that it, Great Britain, would start demarcation without Venezuela. Venezuela's current argument in its rejoinder that it was, quote, forced to endure against its will the line described in the 1899 award, end quote, simply does not hold up against the facts. Indeed, It was Venezuela that first insisted in a letter from its foreign minister, Mr. Andueza Palacio, to the British Foreign Office dated 29 March 1900, less than 6 months after the arbitral award was issued, that the demarcation of the boundary was, quote, a matter of such importance, and that, quote, it is mutually beneficial to proceed in all that concerns the sentence of October 1899 by concerted and simultaneous action, end quote. How can Venezuela now argue with any credibility that it was forced to engage in the boundary demarcation against its will? Between 1900 and 1905, the Joint Venezuela-British Boundary Commission engaged in the demarcation of the 825-kilometer boundary. During this time, there was not a single utterance from Venezuela expressing any objection, reservation, or concern about the boundary being demarcated. To the contrary, the Venezuelan members of the Joint Boundary Commission, who reported directly to the Venezuelan Ministry of Foreign Affairs, worked with great commitment and meticulous care to comply with the 1899 award. When the work of the Joint Boundary Commission ended, Dr. Tirado, the Venezuelan Chief Commissioner, reported to the Foreign Ministry. I am personally very proud of being able to present a plan of the outcome of our work, which, considering the very unfavorable conditions under which our various journeys were made, is wonderfully accurate. On 10 January 1905, a formal and official international agreement was concluded on the location of the entire land boundary between British Guyana and Venezuela. Dr. Tirado, who signed the 1905 agreement, described the demarcation as an honorable task. Quote, the honorable task is ended, and the delimitation between our republic and the colony of British Guyana an accomplished fact. The evidence shows that Venezuela fully and willingly participated in the 5-year-long demarcation process and freely and consensually signed the final 1905 boundary agreement. There is no evidence to the contrary. Indeed, just months after the signing of the boundary agreement, Venezuela's foreign minister, in his annual address to Congress on 23 May 1905, voiced his satisfaction that the territorial dispute with Great Britain had finally been resolved. Quote, it gives me particular satisfaction to inform you that the commission charged with representing Venezuela in the boundary delimitation with British Guyana pursuant to the arbitral award rendered in Paris on October 3, 1899, has successfully completed its mandate. This effectively resolves the significant territorial dispute that Venezuela maintained with Great Britain for approximately 3/4 of a century. There is simply no evidence that the foreign minister felt coerced to make this very positive statement that the dispute with Great Britain had been resolved. Venezuela then went on to further affirm its acceptance of the boundary by duly recording the 1905 agreement in the official record of the Ministry of Foreign Affairs of Venezuela with no reservations. On the other hand, there is abundant evidence, Mr. President, that in the course of demarcating the boundary, Venezuela was very strict in ensuring that the boundary followed the 1899 award. It refused to accept any modifications to the boundary as described in the award, even in cases when Venezuela's own chief boundary commissioner, Dr. Tirado, advised it would be to Venezuela's advantage. For example, in October 1905, Venezuela rejected a British proposal for the replacement of the circuitous portion of the boundary line conforming to the watershed between the Orinoco and the Essequibo rivers, as provided for by the award, with the straighter Venamo River. Although the proposal was supported by Dr. Tirado, the government of Venezuela rejected the proposed deviation from the award. The fact that Venezuela felt free to reject Britain's request further counters its claim of so-called structural coercion. An incident that took place in 1911 further evidences Venezuela's insistence that the boundary strictly follow the 1899 award. When a boundary marker near the Atlantic coast was swept away by the sea, Venezuela insisted that the new marker, quote, must be placed at the precise site in which the boundary line between the two countries out the new coast, which was fixed in the year 1900 in accordance with the award signed at Paris the 3rd of October, 1899 by the Mixed Commission Anglo-Venezuela. As the court can now see on its screens, that same year, 1911, Venezuela published a physical and political map of its territory. As shown in the enlarged map, the map follows the boundary established by the 1899 award and is drawn by the 1905 agreement. Also, the legend clarifies that this map was commissioned and signed by the then president of Venezuela, General Juan Vicente Gomez, on the occasion of the centennial of Venezuela's independence. This is but one of many official Venezuelan maps issued over decades that consistently gave effect to the 1899 award, a record we will examine with you today. For decades on, Venezuela continued to respect the line fixed by the 1899 award and implemented by the 1905 agreement. For instance, on 22 February 1922, the Venezuelan Ministry of Home Affairs entered into an agreement with the Caroni Religious Mission, which established a territory where the mission would be responsible for, quote, the civilization and evangelization, end quote, of tribes. The limits of the mission's territory were established in accordance with the boundary as decided by the 1899 award and enshrined in the 1905 boundary agreement. Venezuela continued to freely affirm that boundary. In 1926, Brazil and the United Kingdom agreed that their boundary lay, quote, where Venezuelan territory commences on the said Roraima Mountains, end quote, as established, which was as established by the 1899 award and the 1905 boundary agreement. There was no protest from Venezuela to this agreement between Brazil and Great Britain. As shown by subsequent events, it was quite the contrary. First, only 2 years later, in 1928, President of Venezuela, Juan Vicente Gomez, recommissioned the production of an official physical and political map of the country. As shown in the enlarged image on your screen, that map implemented again the line of the 1899 award and the 1905 boundary agreement. Second, and most importantly, the following year, in 1929, Venezuela implemented that same boundary in its frontier delimitation with Brazil, as shown by the text of that agreement projected on your screens. The frontier between the two countries should be clearly defined from the island of São José to a point on Mount Roraima where the frontiers of Brazil, Venezuela, and British Guyana meet. This was explicit recognition of the fact that the frontier between Venezuela and British Guyana had already been determined. Another compelling example is while fixing the tri-junction point. It became apparent that the boundary marker installed by the Venezuelan British Guyana Boundary Commission in 1904 had been placed on the edges of Mount Roraima, not on its summit, as mandated by the 1899 award. The British suggestion to maintain this 1904 marker was rejected by Venezuelan Foreign Minister Pedro Itriago-Shaquin. In his reply on 31 October 1931, he demanded the reestablishment of the marker as mandated by the 1899 award. In his message, he described that boundary as a frontière de droit. And he explained that, quote, the Venezuelan government regret that for constitutional reasons, they are unable to depart from the letter of the award, end quote. The British ultimately acceded to the Venezuelan position. Thus, that same year of 1931, the marker on your screen of the tri-junction point between Brazil, Venezuela, and British Guyana was established exactly where this point was placed by the 1899 award. The following year, on the 3rd of November, 1932, the Venezuelan foreign minister provided yet another statement, now the Venezuelan proposal that the boundary in question should be a straight line drawn from the source of the Winamo River to the point of tri-junction on Mount Roraima of the frontiers of Venezuela, British. 5 years later, in 1937, the official map of Venezuela was once again updated. As shown on your screens, that update continued to depict the border with neighboring British Guyana in accordance with the 1899 award and the 1905 boundary agreement. The following year, in November 1939, the Venezuelan Ministry of Promotion published a map of the Venezuelan state of Bolivar, which borders Guyana. This map also implements the frontier of the 1899 award and the 1905 boundary agreement. Moving on, as you can see on your screens, in 1940, Venezuela's Ministry of Public Works and its National Cartography Directorate prepared the Atlas of Venezuela, which likewise reflected the boundary as determined by the 1899 Arbitral Award and implemented through the 1905 boundary agreement. In the post-World War II period, as Great Britain began to prepare British Guyana for independence, there was no suggestion from Venezuela that the 1899 award or the Venezuela adhered to the map presented by the United Nations upon its creation. The map clearly follows the border of the 1899 award and the 1905 boundary agreement as shown on your screens. 2 years later, in 1947, Venezuela produced two different official maps, again, implementing the same frontier. First, the physical and political map shown on your screens. Second, the index map of Venezuela's landing sites, now on your screens. Shortly thereafter, and of great relevance, in 1948, Venezuela's Congress promulgated the Organic Law of the Federal Territories. Article 5 provided that the Delta Amacura Federal Territory of Venezuela, quote, is formed by the region found within the following boundaries: the Gulf of Paria and the Atlantic Ocean to the north, the Atlantic Ocean and British Guyana to the east, as defined by the border treaty between Venezuela and Great Britain. In the following year, 1949, the infamous Mallet-Prévost memo was published by the American Journal of International Law. Professor Sands will address that memo in some detail. The point I want to make is that nothing in that memo altered the Venezuelan government's consistent position on the legality of the 1899 arbitral award or the 1905 boundary agreement. Indeed, Venezuela continued throughout the following decade to regard them as legally valid and binding. This is clearly reflected in the official maps it published during this period. I will take you through them. First, in 1950, right after the publication of the Malay-Prevost Memorandum article, it published not one, not two, not three, but 4 different official maps, all incorporating the 1899 award to the letter. The first one on your screens is yet another official physical and political map of Venezuela. The second, now on your screens, is a geological map published by Venezuela's Ministry of Promotion. The third map depicts the eastern natural resources of Venezuela and was published by its Ministry of Mining and Hydrocarbons. The fourth and final one is a mining and geological map of the Venezuelan state of Bolivar, published again by its Ministry of Mining and Hydrocarbons. Again, all these maps faithfully implemented the 1899 award. Venezuela continued to implement this award throughout the 1950s. In 1955, Venezuela published an updated version of its physical and political map, the one commissioned in 1911, and updated in 1928, 1937, and in 1950. As in its previous 4 iterations, this map implemented again the frontier of the 1899 award. The following year, in 1956, the Ministry of Public Works published a map of the Republic of Venezuela, again depicting the boundary of the 1899 award. 4 years later, the same ministry maintained that same boundary in another map of the Republic of Venezuela published in 1960. Mr. President, members of the court, as you are all well aware, 2 years later, in 1962, Venezuela voiced for the first time its legal challenge to the validity of the arbitral award. Yet, that same year of 1962, Venezuela published another map of the Republic of Venezuela, which respects the 1899 award. Mr. President, we have shown to the court through a period of decades multiple official statements of Venezuela recognizing and expressing satisfaction with the 1899 award, as well as clear and consistent conduct demarcating and defending the boundary drawn in accordance with the award. We have presented to you at least 16 official Venezuelan maps spanning the period from 1911 to 1962, all showing the boundary between Venezuela and British Guyana exactly following the line described in the 1899 arbitral award and as demarcated in the 1905 boundary agreement. We have looked for official maps showing a different boundary. We have found none, not a single one. Certainly there are none in Venezuela's pleadings in this case. If they have found one since the filing of their rejoinder late August, and if it is admissible in evidence as a readily available publication, we look forward to seeing it on Wednesday. In Guyana's view, the consistent depiction of the international boundary on Venezuela's official maps is conforming strictly to the 1899 arbitral award and the 1905 boundary agreement over a period of at least 61 years should be given considerable weight by the court. In its jurisprudence, the court has paid particular regard to such maps. In the case concerning the Temple of Priya Vihir, Cambodia versus Thailand, the dispute centered on a particular map which depicted a boundary line produced by a mixed boundary commission opportunities to do so was a determining factor for the court. The court found it significant that Siamese and Thai officials continued to produce the map showing the Temple of Preah Vihear on Cambodian territory all during this time, without placing any reservations or notations on these maps challenging the boundary. The same could be said for Venezuela between 1911 and 1962, which could have included a reservation or notation on its official maps, but never did so. Based on the consistent conduct of Siamese and Thai officials for more than 5 decades, in the Temple of Preah Vihear case, the court explained as follows. Looked at as a whole, Thailand's subsequent conduct confirms and bears out her original acceptance, and that Thailand's acts on the ground do not suffice to negative this. Both parties, by their conduct, recognize the line and thereby, in effect, agreed to regard it as the frontier line. Come now to part 2 of my presentation on the legal consequences of Venezuela's consistent, open, clear, and freely given recognition and acceptance of the validity of the 1899 arbitral award and the 1905 boundary agreement for more than 60 years between 1899 and 1962. The consistent conduct of a state, including by its highest officials, over a period of years can produce legal consequences. One of the leading cases is the arbitral award made by the King of Spain on 23 December 1906. That case is factually and legally similar to the current case and thus of particular relevance here. As in the present case, in 1906, Honduras and Nicaragua had by treaty submitted a disputed part of their boundary to arbitration. The outcome of the 1906 arbitration award favored Honduras. However, it was not until 1912 when, for the first time, Nicaragua challenged the validity of the award. And it was only after decades of failed negotiations the case reached the court in 1960 through agreement by the parties. Briefly, Nicaragua challenged the validity of that arbitral award for reasons similar to those invoked by Venezuela. In particular, Nicaragua claimed that the arbitrator exceeded his jurisdiction, that he committed essential error, and that he provided inadequate reasons to support his conclusions. Honduras defended the arbitral award based on the conduct of Nicaragua, which until 1912 had accepted the award as valid. Nicaragua responded, much like Venezuela, claiming that it was unable to challenge the award early because it had been unaware of the award's defects at the time it was issued and for 6 years thereafter. This argument failed. This court ruled that Nicaragua, by express declaration and by conduct, recognized the award as valid, and it is no longer open to Nicaragua to challenge the validity of the award. Nicaragua's failure to raise any question with regard to the validity of the award for several years after the full terms of the award had become known to it further confirms the conclusion at which the court has arrived. While no case will be identical on all points, the King of Spain case is nearly identical in the relevant aspects, with one notable difference. In the King of Spain case, the time between the arbitral award and Nicaragua's challenge to its validity was just 6 years, whereas in our case, the time gap is more than 60 years, 10 times longer. Venezuela's failure to challenge the 1899 award thus produces legal consequences. By 1962, it was too late for Venezuela to make a viable legal challenge on grounds known to it for more than 6 decades. In its more candid moments, Venezuela itself recognized the weakness of its argument. The same foreign minister who asserted the first formal challenge to the 1899 award, in February 1962, Dr. Falcón-Briceño wrote that existing jurisprudence would, quote, oppose a situation of this kind, end quote, namely a challenge to an award whose validity had already been long accepted. He therefore suggested proceeding ex aequo bono. In other words, Venezuela itself recognized that under applicable international law, its claim could not succeed. In these proceedings, Venezuela has conjured up a new argument to avoid the legal reality that for over 60 years, it has accepted, applied, and acquiesced in the 1899 award. Venezuela now contends that the 1966 Geneva Agreement gave it a new right to challenge the 1899 award it had clearly supported during those 6 decades. This is not a persuasive argument. By the 1966 agreement, Great Britain and Guyana only recognized that Venezuela claimed since 1962 that the 1899 award was a nullity. It did no more than that. It certainly did not address the substance of Venezuela's claim or the grounds on which Great Britain and Guyana could oppose it, or Venezuela's right to raise it 60 years later. It is now for the court to determine whether Venezuela is precluded from challenging the validity of the award on the same basis it could have asserted in 1899 or at any time shortly thereafter or 60 years later. The Geneva Agreement did not revive a right that had long been lost. It did not create a new right. Mr. President, it is Guyana's submission that both the 1899 award and the 1905 agreement are fully valid and that no grounds exist for challenging the legal validity of either. However, we should underscore that the 1899 award and the 1905 boundary agreement are 2 legally distinct juridical acts, and any possible defect affecting the validity of one of them has no bearing on the validity of the other. As stated by the arbitral tribunal in the Laguna del Desierto case between Argentina and Chile, a decision on a frontier dispute and its demarcation are 2 distinct acts, each of which has its own legal force. Venezuela has not disputed and could not dispute the validity of the 1905 agreement, which has stood as a valid treaty for more than 115 years. In any event, by 1962, and pursuant to the principle reflected in Article 45 of the Vienna Convention on the Law of Treaties, Venezuela had lost the right to invoke any grounds for invalidating the 1905 agreement because of its prolonged acceptance not only of the award, but also and particularly of the 1905 agreement itself. Moreover, as a boundary agreement, the agreed boundary has a life independent of the treaty. As the court explained in its 2007 ruling on preliminary objections in the territorial and maritime dispute Nicaragua versus Colombia, a principle of international law that a territorial regime established by treaty achieves a permanence which the treaty itself does not necessarily enjoy, and the continued existence of that regime is not dependent upon the continuing life of the treaty under which the regime is agreed. Venezuela's failure to challenge the boundary agreement and the boundary it established for 57 years between 1905 and 1962 constitutes its acquiescence and results in its forfeiture under Article 45B of the Vienna Convention on the Law of Treaties of any right to challenge their validity. Venezuela cannot avoid these consequences by arguing that it is not a party to the convention. In Somalia versus Kenya, the court held quite that under customary law reflected in Article 45 of the Vienna Convention, a state may not invoke a ground for invalidating a treaty if after having become aware of the facts, it must, by reason of its conduct, be considered as having acquiesced in the validity of that treaty. Mr. President, in conclusion, the evidence is resoundingly clear that from the very instant when the 1899 award was delivered some 127 years ago until 1962, Venezuela constantly accepted, recognized, complied with, and insisted on strictly following the award. It was well aware of any possible grounds for challenging the award. As much as Venezuela now denies this, its officials repeatedly expressed their satisfaction and depicted the outcome as a victory, having gained the most valuable part of the disputed territory, the mouth of the Orinoco River. Mr. President, members of the court, this is the end of my presentation. I thank you for your courtesy, and I ask that you invite Guyana's next speaker, Professor Philippe Sands, KC, to the podium, but perhaps after a coffee break.
I thank Professor Oral. Before I give the floor to the next speaker, the court will indeed observe a break of 15 minutes. The hearing is suspended.